So coming on to PMT 33 discussion. The first question, with reference to Central Water Commission, consider the following statements. First statement, it is an apex level body chaired by Prime Minister. Second statement, it functions as an attached office under Ministry of Water Resources, River Development and Ganga Regeneration. And again, the question is asking for the correct statement. So, which of the statements given above is or are correct? So, regarding the Central Water Commission, it was currently in news, and that's the reason why we have given it in your test series. What exactly Central Water Commission is all about? Central Water Commission is actually a body which is not chaired by Prime Minister. Rather, it is chaired by a secretary, in fact. That is, so here, in fact, it is chaired by a secretary. It is not chaired by the Prime Minister. So, which means that the answer, first statement is wrong. Regarding the second one, it functions as an attached office under Ministry of Water Resources, River Development and Ganga Regeneration. Yes, that is correct. Again, Central Water Commission. So, it has to have its link with Central, that is Ministry of Water Resources. So, it's a common sense. So, thereby you can actually say that second statement is correct. Since it is asked for the correct statement, you can say the answer is B, too only. Now, Central Water Commission is headed by a chairman with the status of ex officio secretary to Government of India. And again, it functions as an attached office of Ministry of Water Resources, River Development and Ganga Regeneration. And in recognition, why it was in news? It was because in recognition of its contributions made by Central Water Commission for promoting health and safety of large dams in India through the World Bank aided DRIP, that is Dam Rehabilitation and Improvement Program. It is actually a Central Board of Irrigation and Power that conferred upon the CWC the Award of Excellence. So, Award of Excellence for 2018 was backed by Central Water Commission. So, this is a current affairs. That's the reason why. Please go through it. It's very important. Now, the next one, 123rd Constitutional Amendment Bill. This also is in a current affairs. It's a very high probable question for a prelims. So, consider the following statements regarding 123rd Constitutional Amendment Bill of 2017. This will make National Commission for Backward Classes a constitutional body. Second one, it aims to provide the Commission authority to examine complaints and welfare measures regarding socially and economically backward classes. The third one, it also aims to repeal National Commission for Backward Classes Act of 1993. And again, the statement is asking for the correct statement. So, we'll just look into it once again. There is first statement, this will make National Commission for Backward Classes a constitutional body. Yes, that is what exactly this 123rd Constitutional Amendment Bill actually tries to. Right now, what we are having is a National Commission for Backward Class. We do have a National Commission for Backward Class, but it is not a constitutional body. And also, it is not that much powerful when you compare with that of the National Commission for Scheduled Castes or National Commission for Scheduled Tribe. In fact, it does not have the power even to inquire upon the instances wherein the rights are violated by the executive, that is rights of backward class as well as Anglo-Indians. If it is violated, the National Commission for Backward Class will not be having that power to inquire upon it and take necessary actions. So here, it is actually the National Commission for Scheduled Castes which is having that power. And this 123rd Constitutional Amendment Bill, it actually tries to take back these rights from this National Commission for Scheduled Castes and give it to the new constitutional body. So the first statement is correct. Second one, it aims to provide the Commission authority to examine complaints and welfare measures regarding socially and economically backward classes. So it is asking for socially, yes, correct, but economically is not a correct statement because in our constitution there is nowhere which has been mentioned as economically backward classes being considered. So economically backward classes is absent from our constitutional provisions. Along with that, you also know that the Supreme Court in many instances have actually ruled out this economically backward class, the economical criteria that is required, that has been brought forward by the executive, especially during Narasimha Rao government's tenure regarding providing them reservation. So which means that the second statement has to be wrong. And the third statement, it also aims to repeal the National Commission for Backward Classes Act of 1993. Yes, that is the act which powers up today's National Commission for Backward Class. So this is this commission, that is 123rd Constitutional Amendment Bill, also seeks to amend or repeal, in fact, this particular National Commission for Backward Classes Act of 1993. So here 1 and 2, first statement is correct, second statement is wrong. while the third statement is also correct. So the answer has to be B, 1 and 3 only. So it seeks to grant National Commission for Backward Classes constitutional status on par with National Commission for Scheduled Caste and the National Commission for Scheduled Tribe. And the National Commission for Backward Class is actually a body that has been set up under National Commission for Scheduled Caste, National Commission for Backward Classes Act of 1993. And this, right now this particular body, that is the current NCBC, has the power to examine complaints regarding inclusion or exclusion of groups within the list of backward class and also advise the central government regarding these affairs. So basically it has, the main power is for examining complaints regarding inclusion or exclusion of groups within this backward class provision. So in order to make it more effective, that is in order to make it more effective and more efficient, that's the reason why this bill has been brought up. This bill seeks to establish NCBC under a constitution, which means that it would be a constitutional body, and provide it to the authority to examine complaints and welfare measures regarding constitutionally and not economically, but instead is educationally backward classes. And the backward classes repeal bill 2017 has been also brought along with this particular NCBC bill, 123rd Constitutional Amendment Bill. It actually seeks to repeal the present NCBC. Now, under the Constitutional Amendment Bill, the NCBC will have a power of civil court by investigating or inquiring into any complaints. And these powers include summoning people and examining them on oath, requiring production of any document or public record, and receiving evidence. So these are actually the basic powers which the current 123rd Constitutional Amendment Bill seeks to provide with the aspired constitutional body NCBC. Now regarding the next question, consider the following statements with reference to Article 301 of Constitution. The first statement, the Constitution directs that commerce and intercourse throughout the territory of India shall be free. Second statement, this provision however does not apply to intrastate trade. Third statement, with previous sanction of the President, the state legislature can impose restriction on freedom of trade, commerce and intercourse. So again it is asked for the correct statement. So first statement, the Constitution, that is with reference to Article 301, yes, 301 deals with interstate trade. So the Constitution directs that the commerce and intercourse throughout the territory of India shall be free. Yes, that is correct. That is the Constitution mandates as per Article 301 to provide for a free intertrade as well, intercourse as well as the commerce throughout the territory of India. So first statement has to be correct. Second statement, this provision however does not apply to the intrastate trade. This is a wrong statement because it applies to both inter as well as intrastate trade also. So which means that the second statement has to be wrong. The third one, with previous sanction of the President, the state legislature can impose restriction on the freedom of trade, commerce and intercourse. That is the correct statement. That is with the previous, that is the prime sanction of President is required. Only then the state legislature can impose restrictions in fact. And along with that, the Parliament is also empowered to place restrictions on this particular that is restriction on freedom of trade, commerce and intercourse. Now we look in, so here first statement is correct. Second statement is wrong, third statement is also correct, so answer has to be C, 1 and 3 only. Now Article 103 deals with, declares that the trade, intercourse and commerce throughout the territory of India shall be free. And the object of this provision is to break down the border barriers, that is break down the border barriers between the states and create one unit. So this is the basic aspiration, that is in order to remove all the barriers that is existing within the country. Create a single unified country which actually fosters a sense of unity and also dispels the myth of regionalism or the orthodox ideas of regionalism. So that is what actually this particular provision deals for. With the view to encourage the free flow of trade, commerce and intercourse in the country, the freedom under this provision is not confined to the interstate trade, commerce and intercourse, but also extends to intrastate trade, commerce as well as intercourse. And the Parliament can also impose restriction on the freedom of trade, commerce and intercourse between the states and within the state, but it is based on the grounds of public interest. Along with that, with the prior recommendation or the prior sanction of the President, the state legislature can also impose reasonable restrictions on the freedom of trade, commerce and intercourse, and also the legislature of a state can impose on goods imported from other state or union territories any tax on which similar goods, that is, so here what it happens is that the state legislature, that is, consider a scenario wherein in Karnataka, that is, this is a scenario wherein in Karnataka, a good is being manufactured. And the same good is also manufactured in Tamil Nadu as well as in Kerala. But what happens is that in Tamil Nadu, the tax that has been imposed on this particular goods, that is, this particular good, let it be A, is 0, while in Tamil Nadu as well as in Kerala, it is 5%. Imagine this scenario. In such a case, if a producer or if a import, that is, if a trader is actually, so if a trader thinks that, okay, since there it is 0% tax, here I am having 5% tax, so since interstate trade is etc. is free, I can actually bring it from Karnataka and sell it here and make profit. So in such a scenario, in order to prevent such misuse, that's the reason why the legislature of a state can impose tax on goods imported from other states or the union territories, any tax which similar goods manufactured in that particular state is subjected. So which means that, so for that particular good or that particular goods which is being manufactured, if it is to be imported from Karnataka, the Kerala state legislature as well as the Tamil Nadu state legislature can impose 5%, which is equivalent to that which is being imposed on the same goods that is being manufactured in Kerala as well as in Tamil Nadu. So that is what, so here it actually, that is not actually a violation of this particular article 301. The freedom is subject to nationalization law. That means the law providing for monopolies in favor of centers. That is, there may be several scenarios wherein a particular area would be nationalized by the central government or the state government. So in such a case, this particular law will not be valid there. And next question, we consider the following statements. With respect to states and union territories, the administrator, first statement, the administrator appoints chief minister in union territories having assembly, while governor appoints chief minister of a state. The second statement, unlike states in union territories, president can return any bill reserved by the administrator for his assent. The third statement, recommendations of the lieutenant governor is mandatory for union territory government before moving a bill related to the Consolidated Fund of Union Territory. So these, again, the demand of the question is for not correct statements. So please have a, so before you get your question again and again, I am repeating it. Just go through it, understand what exactly the question is demanding, whether it is a correct statement, it is asked for the correct statements, or whether it is asked for the not correct statement. So I have this idea crystal clear. Now regarding here, the administrator appoints chief ministers in union territories having assembly, while governor appoints chief minister of state. The latter part, that is governor appointing chief minister of a state, is correct. That is, it is actually the governor that appoints, but here, the first one, that is administrator appointing chief minister of union territory, is a wrong statement. It is not the administrator who appoints. In fact, it is actually the president who appoints the chief minister of union territories with legislature. So here in this particular case, we can say that in the case of Delhi as well as in the case of Puducherry, we can say it is not the lieutenant governors who actually appoint the respective chief minister. It is actually the president of India who appoints them. So the first statement is wrong. That is, administrator is not appointing the chief minister of union territory. Second statement, unlike states, in union territories, president can return any bill reserved by the administrator for his assent. So that is also a wrong statement. That is, president can, here you can actually look for the absolute statement, like absolute words, in fact, any bill. So it is not that this particular criteria or this particular trick will work every time, but again to 70 to 80% you can expect it to work. So here the president can return any bill. Any bill is not correct because in the case of money bills, the president cannot return this. It can actually, the president can reject or give his assent, but again he or she cannot actually return it. So which means that the second statement is also correct. In case of union territory also, the president cannot return. So the second statement is wrong. The third statement, recommendations of the lieutenant governor is mandatory for union territory government before moving a bill related to Consolidated Fund of the state. So here again, so recommendation of the lieutenant governor is mandatory. Yes, that is correct. That is mandatory for the union territory government before moving a bill which involves expenditure from Consolidated Fund of that particular union territory. So third statement is also correct. So which means that since it is asked for the not correct statement, the answer has to be first statement as well as second statement. That is 1 and 2 only, which means that answer Bombay has to be the answer. Now the union government can exercise executive and legislative power on all state subjects with reference to union territory. which is not possible in a full-fledged state government. And according to Article 244, the President has power to make regulations for a union territory unless the legislature, that particular legislature of that state, does. And again, if even if there is a legislature, the administrator can reserve it for the assent of the President, who might return it but not reject it. So according to Article 244, the President has the power to make regulations for union territories unless there is a legislature for that particular union territory. And again, the governor appoints the CM. That is, in this particular state, in the state's case, it is actually the governor who appoints the chief minister. And in the case of union territories having legislature or a legislative setup, in such a case, it is not actually the governor, but instead it is actually the president and also the CMs, that is the chief minister of this particular Delhi as well as Puducherry. They will be holding office until till the pleasure of president. It is not the governor, it is president. And prior sanction of the administrator is required for the certain legislative proposals involving judicial commissioner, and also recommendation of the lieutenant governor is obligatory for union territory government before moving a bill or an amendment that is to be provided for an imposition, abolition, remission, alteration or regulation of any tax, and also amendment of a law with respect to any financial obligations undertaken or to be undertaken, anything that has to do with the Consolidated Fund of Union Territories. So anything that is to be dealing with the Union Territory, the Consolidated Fund of Union Territory, the President's, that is, Lieutenant Governor's prior recommendation is necessary. Now regarding the next statement, Constitution provides that the President is an integral part of the Parliament. This is because he is a nominal head of the state. Is it correct? President, is it because that the Constitution provides that the President is an integral part of the Constitution? Of the Parliament. No, it is not because that he is actually a nominal head of the state. Nominal head of the state means it is actually with reference to the executive power. So it largely deals with the executive power, and that's the reason why A cannot be the answer. Second option, Bombay, B option, the executive power shall be exercised by him either directly or through officers subordinate to him. So again, this is also speaking about the executive power. It is not speaking about the legislative setup. So that's the reason why we can say option B, Bombay, is also not correct. Say third statement, he summons and prorogues the session of the Parliament. It is actually, it seems to be a bit correct. But again, let's go for the fourth statement, the final statement. The bill passed by both houses requires assent of the President in order to become a law. Again, that is the correct statement. That is, in order for a bill to become an act, that is, which is purely a legislative setup or legislative act, the President also needs to give his assent. So that's the reason why we can say President is actually a power. That is, President is also an integral part of Parliament. Again, summoning as well as proroguing the sessions, that actually is not involved directly with that of the legislative setup, but again, it is actually having some connection to the legislative. But the direct impact lies in the fact that the bill passed by both houses has to be given or has to be assented to by the President. So that is the main issue, or it is actually the main answer in fact. So answer D, option D, that is the bill passed by both houses require the assent of the President in order to become a law. Now, next statement, consider the following statement. Secretariat of the Parliament is headed by the Parliamentary Secretary according to Representation of People Act 1951. Parliamentary secretaries are given less important portfolios under their control. There is only one secretariat for both houses of the Parliament. And again, it is asked for the not correct statement. So here, once again, not correct statement. So the first statement, Secretariat of Parliament is headed by a Parliamentary Secretary according to the Representation of People Act 1951. So again, Parliamentary Secretary is nowhere. So this is actually a myth. That is, as soon as you see the name, that is Parliamentary Secretary, you may link it something with that of the Parliament. But again, it is actually something which is linked with that of the Executive, and that's the reason why we can say Secretariat of the Parliament is not headed by the Parliament Secretary. Instead, it is actually headed by the Secretary General. And so, which means that the first statement is wrong. Second statement, Parliament Secretaries are given less important portfolios under their control. In fact, they don't have any portfolios as such. They will be assisting us at a government, ministry. So, second statement is also wrong. Third statement, there is only one secretariat for both houses of the Parliament is also a wrong statement. Both Lok Sabha has its Lok Sabha Secretariat, Rajya Sabha also has its Rajya Sabha Secretariat. So these two secretariats are wrong. I'm sorry, these two are actually separate, and that's the reason why we can say The third statement is also wrong, which means that since it is asked for the not correct statement, C has to be the answer, that is 1, 2 and 3. Now regarding the Secretariat of the Parliament, each House of the Parliament has its own separate Secretariat staff of its own, though there can be some posts common to that House. Their recruitment and service conditions are regulated by the Parliament, and also the Secretariat of each House is set up by the Secretary General, it is not by the Parliamentary Secretary. And he is also a permanent officer, and again the Secretary General is appointed by the presiding officer, and his recruitment as well as service conditions are regulated by the Parliament itself. And regarding the Parliament Secretary, it's very important, it's a highly potential question for your prelims as well as for your mains also. Now they are members of the last category of the Council of Ministers. They are also known as Ministry, that is Council of Ministers, and they don't have any separate department under their control. They are attached to senior ministers and assist them, and assist the senior ministers in discharge of their duties, in their parliamentary duties. It is not purely of executive duties, it is actually something of parliamentary duties. And however, since 1967, no parliamentary secretaries have been appointed except during the first phase of Rajiv Gandhi government. Again, recently it was actually the Delhi Union Territory. The Delhi government had appointed certain parliament secretaries, which was quashed down by the High Court, Supreme Court also. So that's the reason why it was in news currently. That's the reason why you may get a question on this for April 2018. Now, which of the following are charged on Consolidated Fund of the State? Administrative expense of the Supreme Court, salary of the allowances of all members of the Parliament, salaries and allowance of the Attorney General of India, salaries and allowance and pension, salaries, allowance and pensions of Chairman of UPSC, the debt charges for which the Government of India is liable. And again is asked for the correct statement. So the first statement is administrative expense of the Supreme Court. Again, yes, that is correct. That is in order to uphold its independence, etc. That's the reason why the Constitution has given for this particular administrative expense to be listed in the charge expenditure of a Consolidated Fund. So first statement is correct. So if the first statement is correct, you can eliminate option A, 3, 4 and 5. Second one, salary and allowance of all members of the Parliament. Again, members of the Parliament has not been mentioned in the Consolidated Fund of the State. In fact, yes, Consolidated Fund of the State, it has been mentioned, but it is not mentioned as charged upon expenditure that is charged upon Consolidated Fund of India. And the salaries, allowance and pensions of allowances of Attorney General of India again is also not mentioned. So 3 can be eliminated. So which means that here when you eliminate 2 and 3, you can eliminate option B as well as option D, Delhi. Bombay and Delhi can be eliminated. So which straight away takes you to the answer 1, 4 and 5. But again, let's verify it. Salary, allowances and pension of Chairman of UPSC, yes, that is correct. The debt charges for which Government of India is liable, that also is correct. So the answer has to be C, 1, 4 and 5. Now, emoluments and allowance of the President and other expenditure relating to his office, these all are actually expenditure which are charged upon the Consolidated Fund of India. Salaries and allowance of the Chairman and Deputy Chairman, Speaker and Deputy Speaker, salaries, allowance and pensions of the Supreme Court judges, pensions of judges of High Court. It is only the pensions of judges of High Court, it is not actually the salaries also. The salaries of the judges of High Court is actually charged under the Consolidated Fund of that particular state. And here salary, allowance and pension of CAG, of salaries, allowance and pensions of the chairman and members of the UPSC, as well as administrative expense of Supreme Court, Office of Controller and Auditor General, as well as UPSC, including their salaries, allowance and pensions, etc. Everything is actually charged upon the Consolidated Fund of India. The debt charges for which Government of India is liable, including the interest payments that the Government of India has to make, along with the sinking funds charges, as well as redemption charges and other expenditures that is relating to the raising of loans, service and redemption of debts, and also any sum required to satisfy any judgment, decree or award of any court or arbitral tribunal, and also any other expenditures declared by the Parliament so to be charged. So all these would be charged upon the Consolidated Fund of the State. Consolidated Fund of India. Now the Prevention of Insults to National Honours Act 1971 is in consonance with the directive principle of state policy, fundamental duties, fundamental rights as well as basic structure of the Constitution. So which among would be it? National Honours Act 1971, in fact, is actually something which brings in effect to the fundamental duties. That is 51 clause A, 51A, which deals with fundamental duties of this clause A, the very first one. So it is fundamental duties. So, Prevention of Insults to National Honours Act 1971, the act was legislated to prevent dishonor of national sentiments, which also includes Indian Constitution, national anthem as well as national flag. And in consonance with Article 51A, Clause A, the fundamental duty is to respect and abide by the Constitution, national anthem as well as national flag. And it extends to the whole of India. It also extends to Jammu and Kashmir, irrespective of where it is. It is actually extending to the entire part of India. And President, Vice President, PM, Speaker, etc., they would be liable for disqualification if they are found violating this particular law. And the next one regarding parliamentary forums, which of the following statements are correct? The presiding officers of the House are the ex officio members of all such forums. Second statement, every forum has not more than 31 members, that is, every forum has not more than 31 members in it. And 21 members are from Lok Sabha and 10 members are from Rajya Sabha, excluding President, Co-President as well as Vice President. And again, it is asked for the correct statement. So here, the presiding officers are ex officio members of all such forums. Is actually, they are not actually ex officio members. In fact, you can say here, what we can say here, they are ex officio members, but again, there would be, that is except for one particular scenario, it is actually a speaker of Lok Sabha who would be the ex officio chairman, in fact, of that particular forum. But chairman is also a member, so which means that the presiding officer of the House are the ex officio member of all such forums is the correct statement. Second one, every forum has not more than 31 members is wrong. It would be including, excluding chairman, vice chairman as well as co-chairman. So, which means second statement is wrong. 21 members are from Lok Sabha and 10 members from Rajya Sabha, excluding the president, co-president, vice president. So, which means that second and third statement will be contradicting itself. So, that is actually a clue here. So, which means that second, either second or third can be the answer. So, just link which one is there, that is along with one. So, along with one you can see that both second statement as well as third statement is also correct. But again, the second statement is wrong. It is not more than 31 members. It is actually the members excluding chairman, vice chairman as well as co-chairman. So, the answer has to be D, Delhi 1 and 3 only. Speaker ex officio president of all forums except the Parliamentary Forum of Population and Public Health, where chairman, ex officio president and speaker speaker is also the ex officio co-president. So, that is speaker is actually the ex officio president of all forums. But for this particular forum, that is Parliamentary Forum on Population and Public Health, it is actually the chairman of Rajya Sabha who is actually the ex officio chairman. And here the speaker would be the co-chairman. And deputy chairman, deputy speaker, concerned ministers as well as chairman of all department related standing committees will be ex officio vice presidents of all such forums, respective forums, of that respective forums. And also these forums will be consisting of not more than 31 members, which excludes, in fact, president, co-president as well as vice president, out of whom not more than 21 members would be from Lok Sabha and 10 members would be from Rajya Sabha. And other members would be nominated by the speaker or chairman from amongst the various political groups, parties who are having special knowledge in that particular area. Now the next question, consider the following statements: proved misbehavior, unsound mind, undischarged insolvent, incapacity. And again it is asked for the grounds for the removal of judges of Supreme Court as well as High Court. So it is proved misbehavior or incapacity, you all will be knowing it. So 1 and 4 has to be the answer. Unsound mind as well as undischarged insolvent is not a ground for removing Supreme Court as well as High Court judges. So here the answer has to be 1 and 4 only. So a judge of Supreme Court can be removed from his office by an order of the president, and this president can issue this removal order only upon by an address by the parliament in this sense. And it has to be that particular address has to be given or has to be presented to him in the same session for such removal. And the address must be supported by a special majority of each house of the parliament, that is a majority of total membership of the house and also a majority of not less than 2/3 members present and voting. And the grounds for removal are two, that is proved misbehavior as well as incapacity. Now regarding AFSPA, it's very important. AFSPA is in news also. So consider the following statements regarding AFSPA. It gives armed forces the power to arrest anyone without warrant. Second statement, at present AFSPA is in force in Jammu and Kashmir along with some northeastern state but is absent in red corridor states. And again, it is asked for the correct statement. So it gives armed forces the power to arrest anyone without warrant is correct statement. Second one, at present AFSPA is in force in Jammu and Kashmir along with some northeastern state but is absent in red corridor states. That is, red corridor state means those which are affected by the Naxals. So that is also a correct statement. So the answer has to be both 1 and 2. Now regarding AFSPA, it was enacted in 1958, which gives the power, that is power to army as well as the state and the central paramilitary forces in order to shoot, that is shoot to kill, as well as search houses and destroy any property that is likely to be used if by insurgents in that area that has been declared as a disturbed area. And in fact, this act provides army personnel with safeguards against malicious, vindictive as well as frivolous prosecution. And the security forces can arrest without warrant a person, which we have discussed earlier. And even if that particular person is about to commit a cognizable offense, that is, need not be committed after he has committed, but even before that, if the security forces feel that he is going to commit it, then they can actually use this AFSPA and arrest him, that too without a warrant. The state or central government consider these areas as disturbed by reason of differences or disputes between members of different religious, racial, language, regional groups or castes or communities. So it is on these criteria that the government actually declares them as disturbed. And section 3 of AFSPA empowers the governor of the state or union territory, lieutenant governor in case of union territory, or administrator, to issue an official notification in Gazette. And as soon as this official notification is issued, in such a case, the central will be having the power to send a paramilitary force or army to that particular area for the aid of, that is, for civilian aid. And once disturbed, once declared disturbed, the region has to maintain a status quo for a minimum of 3 months according to the Disturbed Area Special Courts Act of 1976. And it is effective in the whole, so as of now, it is effective in the whole of Nagaland, Assam, Manipur, except the 7 assembly constituencies of Imphal and parts of Arunachal Pradesh. Recently, the center had invoked Meghalaya in April 1st of 2018. Now, dynamic role, this is again a conceptual related question. Dynamic roles taken up by the judiciary to dispense social justice refers to judicial activism, judicial overreach, judicial review as well as judicial inquiry. So, judicial activism should be the correct answer, because in judicial activism, the Supreme Court is stepping ahead and then making a correction. So, which means that it is actually coming under judicial activism. While judicial overreach is different, while judicial review, as you all know, it is actually a basic structure of our constitution, and judicial inquiry is also different. That is, it is actually judicial inquiry is something which is related to the removal, etc. Now, here answer has to be A. Judicial review is actually the process by which judiciary reviews the validity of the law that has been passed by a legislature, and the power of judicial review is evoked to protect and enforce the fundamental rights that has been guaranteed in Part 3 of our Constitution. And judicial activism denotes a more active role that is taken by the judiciary to dispense social justice. An example would be suo motu case that has been taken up, as well as public interest litigation, etc. And judicial overreach, judicial activism crosses its limit and becomes judicial adventurism, or it is also known as judicial activism. That is, when it becomes hyper judicial activism, you can call it as judicial overreach. And when the judiciary oversteps the power that has been given to it, it may interfere with the proper function of the legislative or executive organ of the government. Now, the next question, it was in current affairs also, that is, what does pro bono refers to? So, Supreme Court recently had issued a guideline wherein the advocates, they were supposed to provide free of cost legal aids or legal advices for the poor people. So, pro bono refers to A, the principle that someone cannot be tried more than once for the same crime. B, without due reference to other laws, judgment or facts that may have been relevant. C, denotes work undertaken without charge, especially legal work for a client with low income. And D, beyond and exceeding someone's legal power or authority. Again, since I have introduced the concept, you will be knowing that answer has to be C. So, pro bono in fact is actually a Latin phrase. It stands for public good, and it denotes for the work that is undertaken without charge, especially in the case of here, that is legal work for a client which is having a very low income. And Supreme Court's guidelines along which the senior advocate status will be given only to those lawyers who will have fought a certain number of cases pro bono or free of cost in order to be designated as a senior lawyer. In fact, it is actually a welcome step. Now, consider the following. Speaker continues to occupy the office even after the House is dissolved. So that again we'll look at here. Like the judgment of Supreme Court, the conduct of Speaker cannot be discussed in Parliament during the normal business of the House, and the salary and the allowance of the Speaker is charged on the Consolidated Fund of India. The first statement is correct, that is, the Speaker occupies the office even after the House is dissolved. Yes, he actually occupies the office just before the new Lok Sabha assembles. Just before that particular new Lok Sabha assembles, the Speaker will be till then the Speaker's office will be having the validity. And like the judges of the Supreme Court, the conduct of the Supreme Court cannot be discussed in the Parliament during the normal business of the House. And C, that is the second statement is also correct in order to uphold the dignity of that particular position. Second statement has also been conferred. Third statement, the salary and allowances of a Speaker is also charged. That is also correct in order to uphold the independence of that particular office. Third statement is also correct. So the answer, since it asks for the correct statement, the answer has to be 1, 2 and 3 daily. Now the salary and allowance of the Speaker is charged in the Consolidated Fund of India. The Speaker is provided with the security of tenure and remains in office even when the House is dissolved. That is, until a new Speaker is voted or is elected or is removed or he is removed from the office by a resolution of the House by absolute majority. So he will be occupying it unless or until he is actually removed before that particular stage. So normal tenure would be till the new House assembles. And the conduct of the Speaker cannot be discussed in the House except on a motion that is adopted to that particular effect. And the rules of procedure of conduct of business expressly vest residuary power with him, and also the final interpreter of rules and regulations in the business of the House is actually done by the Speaker, and also he is not subject to any jurisdiction of the court. And Speaker does not cast his vote on the bill motions before the House in the first instance, but he will be having a casting vote. So that's it. Thank you.